All right, cool. So I want to welcome everyone. Wish everyone a happy Thanksgiving as they're going into Thanksgiving. Crossing our fingers, lions don't look too bad. And all right, so my name is Chris Berry with Castle Wealth Group. We do these weekly wisdom webinars every week where I just answer questions either people submit ahead of time or questions you have live, or bring up something that's going on in the world of legal, financial, or tax planning. And always start with a positive focus. This week, my positive focus is had a chance to, my mom had her birthday. We'll call it her 21st birthday. Took her and my family and kids to Chicago. So we had a weekend in Chicago, which was kind of nice. Went to the Shedd Aquarium, which my daughter, who wants to be a marine biologist, she just really enjoyed. Then my son enjoyed. And then we celebrated early Thanksgiving yesterday. So I already got some turkey because we're going up to visit my wife's family over Thanksgiving. So my positive focus is just spending time with family. So it's pretty cool. Now with that, let's get into the business. And I'm going to share my screen. And whoops, this button, there we go. All right. Okay. So really it was just one question submitted this week. It's kind of a big one. But if you do have questions, please make sure to put it in. Or if something's unclear, put it into the chat. So kind of bigger question. Whoops. All right. And I just kind of put it all together. So when should a tax ID be created after a grantor passes away with a basic trust? So what we have here is, so we have someone, they've created a trust, and we'll just call it a basic trust. So a revocable living trust. And while you're alive and well, it's what's called a grantor trust, meaning it's taxed at your own income tax rate. So it's just in your own Social Security number. And then, God forbid, you pass away. Then what needs to happen is estate administration. And so what happens now is a successor trustee steps up to basically take control of the trust. And one of the first things they have to do is get a death certificate. So there's kind of two things that have to be done. First of all is get a death certificate. That's going to come from the county or the funeral home. And then the second thing with that, to appoint that successor, or to have that successor trustee step forward so the financial institutions know who to work with, they need a certificate of trust. And that's something that we can do. God forbid you lose a loved one. Okay. So these two things are always necessary. Now, what happens is you pay off the final expenses, et cetera, and then you can start looking at distributing the assets. But sometimes what needs to happen is we have to open up like a trust checking account. And so after you pass away, if there's not already a trust checking account in existence, then someone needs to get a tax ID number. Not hard, we get it for our clients, but you just go to irs.gov and you can, it takes about 15 minutes, assuming the IRS website is up and working, which isn't always the case, but you have to get a tax ID number from the IRS. Always, just a little tip, always use date of death, or almost always use date of death as the trust existence. So don't say if like the trust was done November 22nd, 2015, and someone passes away this year, you wouldn't use the November 15th or November 22, 2015 date for the existence of the trust, because then the IRS is going to think that you owe all these like back tax returns and stuff. But you need that tax ID to, account to open up, or a tax ID number to open up another account. So when should the tax ID be created after the grantor dies? Sometimes you actually don't need one, but if there isn't already like a trust account to deposit funds into, then you have to get that tax ID number. And that's always something that we can help you with. Is there a website so that's kind of the first question. Is there a website to do that? Yep, it's at irs.gov. If someone dies with a legacy trust, does a new tax ID need to be created for the grantor for final tax purposes in addition to the new INs for beneficiary? Okay, so what we're talking about here is first a basic revocable trust just says it goes outright to the beneficiaries. And then they can do whatever they want with the money. What this is talking about is instead we have still a revocable living trust, but we call it a legacy trust. And what happens there is instead of it going outright, it's held in trust for the beneficiary. So if you have two kids, kind of splits into two separate shares. First, you have to handle kind of the estate administration. And you may or may not need a tax ID number for that. You may or may not, like I talked about, before. If there's already an account open or a trust account open, then you don't need you might not need a tax ID. But if you do have to open up a bank account or a checking account to pay the bills and have everything kind of flow in, then you might need that tax ID to handle the estate administration part. And then the second part is, yes, each one of these will need its own tax ID number. Okay, so it's not going to be now in the Social Security number of the beneficiary, but instead this is going to have its own tax ID number. To answer the question, yeah, each beneficiary will need a separate tax ID number. So if you have two kids, then there's two beneficiaries, then you need two tax ID numbers. So that legacy provision or that legacy trust, each needs its own tax ID. And again, it's not complicated. It takes like 15 minutes. And if you're working with our office, obviously we can help you to get that done. Are there any special forms needed to close basic trust after assets have been distributed? So that's done. Are there special forms notifications needed to close a basic trust after the assets have been distributed? No, closing a trust, there's nothing that really needs to be done. Trust isn't, here's a question. Please explain the difference between a revocable living trust and a legacy trust. They're both revocable living trusts. It's just how do we leave things upon death? One way is outright distributions. So just outright at age 25 or 30, 35. The other way says it's held in trust for lifetime. So it's just how do you leave assets upon death? You can leave it outright at specific ages. That avoids probate, controls the distribution, or you can leave it to the beneficiaries in such a way that whatever they inherit, they can keep it in trust and it can be protected for their lifetime from divorces, creditors, bankruptcies, etc. So they're both revocable living trusts. The big difference is just how are you leaving things to the next generation, whether it's outright or at specific ages or with opportunity that whatever they decide to keep in trust would be protected. And in that case, you would need a separate tax ID number for each beneficiary. Okay, so closing out a trust, the trust itself, it's like a suitcase. So you have assets that are in the suitcase, right? Whoops, no, that's not what I want to do. But so you have these assets that are in the suitcase. So let's say we have different assets in here. So we have like a checking account, we have a house, we have an investment account. And so someone passes away, then typically you're paying all the bills out of the checking account. And then once all that's done, then you distribute the assets out of the trust, okay? And now there's nothing left in the trust. And there's not any paperwork or anything that has to be filed to wrap up the trust. It's just empty at that point. So there's nothing, no additional forms or paperwork. There's nothing that's filed. The only thing that has to happen from a tax perspective is you have to pay taxes for the deceased individual for the last year. Like I had a family come in today. Their mom passed away. She was 97. And so the family has to handle this last year's tax return. So they have one more tax return for their mom, which will be filed next year, but it's from like January till November. And then assuming they wrap up everything, handle the whole estate administration within a year, there shouldn't be any additional taxes. So there shouldn't be any taxes that the estate has to file or anything like that. So really, there's no like special forms or anything that have to be filed. See if we have any questions. Oh, here's something that popped in. All right, let me get that in a second. Are there special, I just did that. Does your firm assist with the probate process? Yes. Though if there are assets going through probate, I'm not the attorney that handles that because I try to keep people out of probate. I have another attorney that handles any probate, and whether it's a simple probate of just some asset ended up going into probate, and then now it has to go through the probate process to find the beneficiary, or if there's a contested probate, I have another attorney that works on all that. But ideally, we're avoiding probate. And comments like treasury bonds are just a pain to deal with. I typically tell people just like try to cash them out. Does your firm handle estate tax filings? Yeah, we have a CPA that's affiliated with us. I'm not a CPA, but we do have we have a CPA that would handle any estate tax filings. All right, so that was all the initial questions. Here's a couple things that came in. And if you do have a question, either something unclear about what we're talking about today or anything else in the legal, financial, tax world, feel free to put it in the Q&A. Is it true that you need to obtain a separate EIN for final tax purposes after the original trustee, grantor of revocable trust dies? Or would final taxes be paid under the deceased Social Security number? Yeah, so like I said, typically you're not going to have to file like a trust tax return or anything else. You would just wrap up under the deceased individual Social Security number, whatever their last year's taxes are. So in this situation that I talked about this morning, their mom was 97. She had a revocable trust. She passed away. We were managing some of the investments. So we're going to have to do her last tax return. And then she gets to step up in basis on everything that wasn't IRA money. So really, there's not much of a tax consequence for the kids. And if we get everything wrapped up within a year, we're not going to have to file any additional taxes. So that's why we try to wrap things up relatively quickly, just so that we don't have to worry about any taxes, especially paying estate or trust tax rates, which are at much compressed tax rates. Like, do I have it handy? Oh, here we go. Yeah. So for example, like married filing jointly to get into the 37% tax bracket, you have to have over $628,000 worth of income. For an estate or trust to get into the top tax bracket of 37%, you have to have $13,000 or $13,050 of income, and then you're in the 37% tax bracket. So as much as possible, we try not to have any estates or any trusts paying taxes. We always want to do it at an individual level, either under the deceased individual's tax or under the beneficiary's tax. So I'm trying to think of a situation in my 16 years where we haven't had an individual pay the tax. I can't think of any. Yeah, so we always have individual, whether it's a beneficiary or the deceased individual, pay the taxes. So thank you for that. Here's a question. We have what is, here, I can stop sharing my screen. We have what is written as an inheritance trust for our son that indicates the ages when he gets certain amounts. Is this the same as a legacy trust? No, I'd say it's the same as a basic revocable trust. in the sense that you're making distributions at specific ages. So it's going out right at age 25, 30, 35. So typically we see like 1/3 at age 25, increase to half at age 30, the remainder at age 35. Well, all you're doing is just launching like pillowcases of money over what I call the wall of time. We don't know what's going to happen. Like if your son or daughter gets divorced at 36, half that money could be lost. Or if they pass away, all that money might go to a spouse who might remarry versus going down to potential grandchildren. So when we talk, and again, we in the financial and legal and tax world, we kind of make up our own names for things. So that what we call a legacy trust would be different than what you're calling an inheritance trust. I would call that a basic revocable trust. And it's really common when you have minor children, you don't know what's going to happen. You say, okay, I want to protect them from their own poor financial management, protect them from making poor decisions, not while they're minors, but young adults. Like I remember what I was doing 18 to 25, and if I inherited 5,000, 50, or 500,000, I would have been the coolest kid on campus, but that would have been my only year on campus, right? So that's what a basic revocable trust does when you build in those ages. You're protecting against their own poor financial mismanagement, where, okay, we'll give you some at 25, increase to more at 30, and then the rest at 35. But the problem is what happens after that, or what happens if life throws them a curveball. And that's where that legacy trust comes into play, is instead of saying it goes outright at specific ages, now we're building in the opportunity. So whatever we leave to the next generation is protected from divorces, creditors, bankruptcies. And then if that individual passes away, the money doesn't go to the in-law, where typically it would go, could go down to the grandkids and be protected. So very big distinction between your typical revocable or typical basic revocable living trust that says outright distributions at specific ages. So. All right. Any other questions? Feel free to type them in. Give everyone a minute or two if they do have any questions. All right. Looks like we covered everything. All right. So with that, here we go. Thanks and have a happy Thanksgiving. Yes, thank you. My pleasure. Everyone have a great Thanksgiving. We'll be back next week. Hope you have a great holiday. I sent everyone at my office home. I'm still here, but everyone else is home. So yeah, so spend family. Go Lions. Happy Thanksgiving. Take care. Bye-bye.